Are you all set, Mike?
All good to go.
All right. Welcome everyone to today's webinar, 2024 Federal and New York State Employee Handbook Updates, presented by Michael Sciatti with Barclay Damon. Many thanks to our presenter, Michael, for being with us today, and to all the participants who have joined in. Please note the webinar is being recorded to share what we learned with the business community. All attendees will receive the link to the recording. He will share the presentation with you, then follow with time for questions and discussion. Please use the chat to submit any questions during the presentation. And just a reminder, when others are speaking, please keep your audio on mute to minimize background noise. With that said, I'll turn it over to Michael to start things off.
Great, thank you, and Happy New Year, everyone. Let me just make sure. What are you seeing? This is... All right, let me share that. Can you see my slide now?
Yes.
Awesome. Technology is great, except when you rotate from Zoom to Teams to WebEx, everything's just a little different. So welcome, Happy New Year. Today's webinar is on employee handbook updates. Now, I've been practicing law since 1991. The employee handbook is and remains your front line of defense. It is the single most important document that you can keep up to date, make it refined, very direct, and have in place all the required policies. If you have a handbook, and that's the good part, if you have a handbook and it's not up to date and you don't keep it up to date, it is your worst enemy. You're better off not having one than actually having one. Because if it's wrong, if it's out of date, if you don't comply with DOL updates, if you don't keep your sexual harassment prevention policy or your FEMLA policy or your paid family leave act policy up to date, it can and will be used against you by the plaintiff's attorneys, or if the government is conducting an audit or an investigation, they may point it out to you and saying, hey, look, your policy is not in compliance. We're seeing it pretty consistently. So let's start with that. It is your front line of defense, the single most important thing. It has to be kept up on a regular basis. So my agenda for today is I want to talk about some general concepts. First of all, really nothing more than common sense, but it presents issues if I have to defend you and the handbook doesn't flow right, or a jury or a judge doesn't follow it. So these are lessons I've sort of learned over the years to make it easy, but they're simple, and we'll go through that. We're going to then talk about major policies, and not all the little things. I'm not going to talk about the history of the company, or what do you do if X, Y, and Z occurs. The simple things that I'm going to leave to you to fine tune. But I'm going to talk about the major things. I think that is the most important thing that you can gather from this, point out to you where some of the changes have occurred, point out to you where we're seeing issues with employers and not keeping their handbooks up to date, where plaintiffs' attorneys might use it against you. Also remember, there's two types of major policies: required and suggested. So let me give you an example of a required policy. The labor law requires that you put in writing your policies on vacation, on PTO, on holidays. Not optional. We have to have it in writing. I say put it in your handbook. You must have a paid sick leave policy. Not optional. Put it in your handbook. You must have a paid family leave act policy. Not optional. Put it in your handbook. So those type of policies are mandatory, and you must have. And if you don't, wow, we need to get you straight sooner rather than later. And again, the government doesn't make it difficult for you in this regard. Yeah, it seems like at times they pile on, but that's okay. A lot of times they give us sample policies. So for instance, the state's sexual harassment policy, which I think now is about 11 pages long, I say adopt it. And make it your own, and don't try to draft your own to be in compliance. I think if the government were to audit you or it comes up in litigation, the best defense is that I adopted the state's policy. Now, let me warn you about something. When you take a boilerplate policy, please make it your own. So I'm reviewing handbooks, and some of the things I see in there, insert name, insert name, insert name. They took the state's policy, put it in their handbook, didn't bother to read it, and didn't realize there were blanks in there. Your policy is ineffective at that point, and it makes you sort of look foolish. So if there is a model policy out there, and we'll go through some of them, make it your own. Don't just simply cut and paste. And I warn you, if you're cutting and pasting handbooks from other companies may have requirements that you don't. So they could be a federal contractor. They could have a federal contract or grant that requires certain drug testing policies that maybe you don't. Every handbook has to be fine-tuned to the business itself. And it's not a hard process, but it does take some time to get everything in order. So with that background, let's sort of jump into this a little bit. Again, I've already mentioned it's your front line of defense. At a minimum, we're looking at yearly updates. I have yet to have a year in the practice of law where something has not occurred at the federal or state level that required some modification of an employee handbook every year in that regard. I am a fan, and we'll talk about sign-offs in a minute. I'm a fan of redistributing the handbook every single year and getting new sign-offs in that regard. So just simple thing, do those yearly updates. Another thing we're seeing is companies have a handbook in place, but they don't train their managers on it. And some of the managers are ignorant as to what's in the handbook or how to implement it. You need to train your managers on the key parts of the handbook, not everything, but when an employee comes to you, I need a reasonable accommodation. I have a heart condition. I need to work part-time from home. That's the request, just hypothetically. Does the manager need to respond to that? Absolutely not. I would tell the manager should not respond to that. It's a request for a medical or disability-based reasonable accommodation, and we need to follow our policy. We must have in place a reasonable accommodation policy. It's another required one. Those requests should be centralized. And when we train the manager, we say, hey, if you're confronted with this situation, this is what we want you to do. Another one that we see problems with, this is actually out of a litigated case. And I had I defended the employer, but this is sort of how it went down. The manager didn't know what to do, why they weren't trained. The coworker that the person supervised wasn't really, well, was it a coworker? Was it a subordinate? There was an issue whether this person was a supervisor. I thought they were. Reported to the shift supervisor, the chief operating officer is touching me inappropriately when he comes into the convenience store. What happened? The shift supervisor, very nice lady who I interviewed, had good intentions, put her arm around her and said, quote, honey, I'll try to protect you, close quote. I asked this person, why didn't you report it to the owner? Why didn't you report it up the chain of command? And she looked at me, she said, was I supposed to? No one told me what to do. You must train your managers. That is extremely important. Have a half-day training every year. Train them on the sexual harassment policy, train them on the handbook, do all the training, get it out of the way, videotape it if you have multiple shifts and you can't get all your supervisors together. Single most important thing to train managers. And when I do it, I tell you, it turns into a glorified Q&A session, which is good in that regard. So train your managers. Electronic versus printed handbook. I don't care. If it's electronic and you get electronic sign-offs, that's great. You just have to be able to prove to me that the person electronically signed off on it. If someone wants a printed handbook, give it to them. Some people aren't very tech savvy. Some people in your organization may not have access to a computer. Give them printed ones. Don't be afraid to do some electronic, some printed. It's going to make your life easy. Sign off by the employee. Let's start with new hires. Do not allow them to work until they have signed off on your handbook and done all the paperwork, all the withholding forms, the I-9 form, the notice of pay rate that the Department of Labor requires here in New York. All the paperwork I want signed before they start working. Best case scenario, best practice. Yearly updates on the handbook, and it may be a redistribution of the entire handbook, or maybe mid-year you distribute a new policy that the Department of Labor rolled out and now requires. Get the sign-offs. Chase the people down that don't sign off. Maybe have a group meeting, say, please sign off on that you've received the policy. And then I think we have some people that are just disgruntled and they don't want to sign off. What I would do is hand them the policy, have another manager present with you, gave it to Johnny on such and such a day, have you sign it and the other manager sign it, and leave it at that. Now, if you want to be really sneaky, take a copy of that policy, mail it to them, certified mail, return receipt requested that only they can sign for it, and in a blank envelope with no company name on it, and let's see if they sign for it. That's a sign off as well. We've done that with some recalcitrant employees. So get the sign off. It is very important. I cannot tell you how many cases we've litigated where the sign off was key and we didn't have it for the plaintiff. The effective date, put it in the handbook. I like putting it at the bottom of every page, effective date, such and such. That way, when you roll it out, we know what it is. Keep all the copies of the old handbooks. I need them if you ever go into litigation. I had one company that kept overwriting it and just kept one main document and kept overwriting it. They couldn't tell me what the handbook said in a certain year. They couldn't tell me what policy was in effect on October 1, 2019. Yeah, it became a problem for us. So put effective dates in there. Don't override the old copies. Keep them up to date. Page numbers, section numbers, table of contents. Great. I strongly encourage it. Remember, I'm looking at this from the worst case scenario. You're being audited by the Department of Labor, U.S. Department of Labor. You have a human rights complaint. You're before an administrative law judge. Maybe it's an unemployment matter, or you're in litigation. Make it easy, not only for yourself, but if you ever are put under the microscope in any one of these scenarios, we want to be able to simply show, here's our handbook. It's really good. That's the objective. Mid-year changes may occur. I mentioned a minute ago, maybe the Department of Labor rolls out a new policy based on, a change of law. So for instance, I think it was last year, the DOL and Division of Human Rights rolled out the new sexual harassment policy. Okay, let's put it in place and tailor it and get it going. The DOL last year put out the new expression of breast milk in the workplace policy. Okay, let's tailor it, make it our own, and put it in our handbook. And the same thing, sign-offs. I had someone ask me once, Mike, can I hold a paycheck till the employee signs off? No, you cannot. I think legally you could say to the person, I'm not going to allow you to work until you sign off on the policy. The National Labor Relations Board may have an issue with that, but I think it's fair because you're trying to run a business and you're not doing anything illegal by putting in place these policies, knowing some of them are in fact required. So let's talk a little bit about some general policies. And again, don't go crazy. Just I want you to take what I'm giving you It's not everything. I have an all-day employee handbook course. So we got 1 hour roughly. Is this in your handbook? I want you to ask yourself. And if so, is it accurate or do I need to change it? If it's not in your handbook, should I add it? Is there a reason to add it? Maybe it's mandatory, in which case you have to add it, or it's a good idea. So define your types and categories of employees. Full-time, part-time. Remember, you define what full-time means. The Department of Labor, both federal and state, care about one thing. If you're a non-exempt employee and you go over 40, you get time and a half. All right, that's what they care about, that you owe that overtime. Very simple rule. But what if we define full-time as 35 hours? That's fine. What do we pay the non-exempt employee between hours 35 and 40? Still straight time. When they hit 40, they get time and a half. So define full-time, define part-time, tie in the benefits that those people can get. You may have seasonal or temporary employees, put those in there, and define generally exempt and non-exempt. Very simple. Exempt employees, if properly classified, you don't have to pay overtime if they go over 40 hours. Non-exempt, you do. Put some general description of that in there. And remember, just because you say someone is exempt doesn't mean they are. You have to pass the salary test, the duties test, and they must be paid on a salary basis. Typically, for the exceptions, there are different requirements for each one, but make sure of that. So again, make sure that it is in there. Some general employment policies. Number one, at-will employment. Now, some of you have the pleasure of having a union, which is fine. Actually, I think it makes life easier sometimes. And you're going to be governed by the collective bargaining agreement that you negotiated. But have a at-will statement in there. The employer, can end your employment at any time for any reason, with or without notice, as long as the reason is legal. Now, let's use some common sense when we implement and practice this. Schiatti, I don't like the color of your sweater. You're fired. Is that a legal firing? It is. It's also stupid. Two tests for a good termination. Is it legal and does it make sense? So I may terminate you for the color of your sweater, but boy, do you think a judge and jury are going to look at you funny like, really? What planet are you on? Why would you do that? Make sure the termination makes sense, is properly documented, etc. Hiring and orientation policies. I want all the paperwork done, any orientation done before they start actually doing the nuts and bolts of it. Performance reviews. Folks, if you have a performance review policy, follow it. If you don't want to follow it, take it out of your handbook. Why? Because the jury or judge or the government might hold it against you. So you're supposed to do a performance review of Johnny every year. You don't do it. And suddenly you claim he's a bad employee. And Johnny runs and gets a plaintiff's attorney to represent them, or maybe files a claim with the Division of Human Rights on his own. Where's the proof that he did a bad job? Well, we never did the performance reviews. Here's another problem we see with performance reviews. Some employers use them as a cheerleading mechanism. They only put good things in there. Don't do that. We want the good, the bad, and the ugly. And by that, I mean the following. If the employee does something well, put it in there. If the employee does something poorly, put it in there. If the employee has a bad attitude, put it in there. Don't just say nice things about an employee. True case, this went to litigation. The employee was terminated. She claims she was terminated because of her sexual orientation. They say, no, it was performance review. I look at the performance review and I say, there's nothing in here but comments of praise. And it's 3 weeks old. And now you're telling me this employee is the Antichrist and must be terminated immediately, when 3 weeks ago you gave her a stellar employment performance review. Oh, we only put good things in there. Big mistake. It will come back to bite you. If there's a provision on promotions and transfers, put that in there. Please remember your general requirements on posting the salary amounts now if you're going to post internally positions. Separation from employment. Some people put in there, like a notice provision. Hey, we want blank period of notice, 2 weeks, 4 weeks. You could have different notice periods for different people. What happens if you don't pay your notice provision? Well, we're not going to pay you. If you don't give us notice or you don't serve your notice period, maybe we're not going to pay you out your PTO, but it has to be very specific in your policy that that's going to occur. That's why it's important to sort of analyze what is the impact of not giving notice? What is the impact of not serving your notice period? Personnel and medical records. Now, personnel files are the property of the employer, and you don't have to allow access unless you want to. And then I would have a written policy. I would never leave an employee alone with their personnel folder for 2 reasons. He might take something out, but we've actually had a case where we had an employee put something in, and then he turned around and sued for racial harassment. And the memo that was put in his personnel folder, and we think we proved it was by him, referred to him all with racially derogatory, offensive words, and it was in his personnel file, so we had to produce it. I think we were able to prove before the case settled to my client's satisfaction that he did it. I think that's why it settled favorably. But be afraid that they might put something in. So and don't leave them alone with it. They have no right to review it alone at this time. A medical file must be kept separate and apart from the personnel file as required by the human rights law, as required by GINA, as required by FEMLA, as required by the ADA. All right. It doesn't mean it's inserted inside the personnel file. It's kept separate, locked away, limited access in that regard. Each of those laws define who can look at the medical file. Generally, it's what you care about as supervisors with a need to know. If the government, if they're investigating you relative to the claim, sometimes you can disclose certain things to insurance carriers. But just remember, there are safeguards in place on medical files. Medical files must be disclosed by OSHA requirements. And, it's very specific. OSHA requires, quote, access to the medical file. Just give them a copy of it. That's really what I say. Access can mean they look at it and they photocopy it. I don't want them to do that. Just give them a copy. References. What is your policy on references? Do you say, hey, after your employment ends, this is who we want you to contact for a reference? I would be very generic, name, rank, and serial number. There is a privilege, a qualified privilege that attaches to job references if done in good faith. I don't want supervisors willy-nilly giving out job references. I think you want to centralize that and, again, put it in your handbook. EEO statement, very simple. We do not discriminate on the basis of, boy, we got a lot of protected classes now, don't we? And I think it's just going to keep expanding in that regard. Make sure you have a catch-all. Catch-all is very important, or any other protected class or status recognized by applicable federal, state, or local law. The law has to apply to you. Make sure you put some type of catch-all in there. Sexual harassment prevention policy, I've already mentioned. I would make this an appendix to your handbook. My recollection of the labor law indicates that every 4 years, the Department and the Division of Human Rights are going to revise the sexual harassment prevention policy. We just had the first revision, I think last year. It went from don't quote me, 9 pages to 11 pages. I think it's only going to expand in that regard. So be conscious of that. Make it an appendix. I think that's the way to go. I also am not a fan of combining the sexual harassment and other types of harassment. That's why I have a standalone anti-harassment, which would cover everything else other than sexual harassment. So I do have a question that popped up. We keep electronic copies of all our files in our HRIS system. Only HR has access to this and has its own folder. Is it okay to keep in that format? The one thing that the law's a little quirky on, the record keeper. There is no exemption that the record holder, meaning the HR department, that everyone can look at it. I asked the EEOC about this about 10, 15 years ago. And I said, look, isn't there really a record? I mean, the person holding the records, isn't that okay for them to have access to? The answer was a little wishy-washy. Supervisors, yes. But I think if, depending on the size and complexity of your HR department, if it's a department of one, you're good. If it's a department of two, you're probably good. But what if it's a department of 20? Do I want the HR person that's doing general payroll to have access to someone's medical records? I don't think so. And that might be a law violation. So just keep in mind, I think it depends on your organization itself. I'm not sure you want to give all your HR or all your payroll people access to all your HR files. And let me give you a good example. So do any of you have nosy employees? They want to know everything that's going on. They could be employed in the HR department. Oh, why did Sandy take FEMLA leave? And you let them go look, but they have no need to know, and they are not part of the FEMLA paperwork process. I think that's a problem. I think you have to put in place some safeguards there. I think IT can help you. I think it's an IT issue, what the people can access. And I think it depends on the reality of how your HR department and payroll department operate. So have the sexual harassment policy, make an appendix, because the DOL will be changing that every 4 years. And the anti-harassment covers all other forms, age, disability, race, etc. Reasonable accommodation policies. There are 3 required, but 4 exist. Let me explain to you the 3 that are required and what this 4th one is and why it's not a standalone policy. I can request an accommodation because of religion, disability, or domestic violence. All are covered by federal and state. The first 2 are covered by federal and state law. Domestic violence is a creature of state law. You must put in place policies for each. It makes sense. The state has now created a 4th accommodation, but it's within the sexual harassment policy and it's within the investigation rules and protocols. Basically, it says you must take into consideration the person's background when interviewing them and whether they'd be comfortable doing an interview in one format or another or a location thereof. It's in the new sexual harassment policy. Just take note of it. I think it's really more for the investigators, and it's a shout out. Hey, use a little common sense when doing your investigation. So the example that I give is when the employee, you're doing the interviews in a room that has lots of windows in the middle of the production room floor, and all the other workers are going to be able to see who walks in there. Bad idea. I've had that happen before, and I was doing the investigation, and I said, "Oh heck no, we're not doing the investigation here," and we got another room somewhere else. All right, let's see. General complaint procedure. Let your employees complain about anything they want. It is your front line of defense. Get a complaint, look into the complaint, and tell the person what the response was. You'll be surprised. Years ago, it was more like employee theft. Topps baseball card company, they make the baseball cards, been doing it for years. There was an explosion in the 90s that baseball cards were worth thousands and thousands of dollars. And what some of the employees were doing were taking cases of the cards and putting it in their car and basically stealing from the company. They got caught as follows. An employee blew them in using a general complaint procedure and basically said, hey, you may want to watch the night shift about midnight every day. They're taking out a case of cards. And they caught them and prosecuted them and fired them. Diversity and fair treatment, anti-bullying code of conduct. These are all policies. It's like, hey, we expect you to behave. We expect you to treat your coworkers, our customers, our vendors with respect and dignity. You don't have to like the people you work with, but we have a performance standard, a protocol. We expect you to do that. Have you ever had anyone, I think I mentioned, that's just a miserable person? Can I discipline someone for being miserable? What is the impact of it? Let's just explore it briefly. Everyone around them doesn't want to work with them. They bring the workforce down. It's really a bad attitude. Can I discipline someone for a bad attitude? Of course you can. Can I fire them for having a bad attitude? Of course you can. Just document it. That's all I ask. Why? It's like, hey, look, you really don't have a good attitude at work, and give examples, put them on a PIP, give a verbal, a written, and then probably terminate at some point. But use that. These are conduct rules: diversity, fair treatment, anti-bullying. And again, you got to sort of train your employees on them. Code of conduct has two parts to it, folks. Number one, affirmative obligations. Show up for work on time, work while at work. Some of your employees do have problems with that. And another one that comes to mind is cooperate with an internal investigation. All right, those are just some examples of affirmative obligations. And then there's the second part, the prohibited conduct. Johnny, don't kick your supervisor, don't spit, don't bite, don't engage in harassment, and the list goes on. Realize the National Labor Relations Board has jurisdiction over non-union employers in the private sector, as well as the unionized. But they take a very close, they're analyzing handbooks now for non-union employers very closely. So just be cognizant of that. Don't overreach with a code of conduct. And let me give you an example of overreaching. Employees are not allowed to take photographs of company property. That is an illegal policy under the National Labor Relations Act. Here's why. I'm a civilian. I can walk across the street, take a picture of your building. It's allowed. It's legal. I've done nothing wrong. Your employee has the same right to do that. And when you question, the HR professional or the vice president that put it in place, they said, what are you trying to protect? Oh, we don't want anyone taking photographs of contracts, of customer lists, of confidential information. Say that. Be very specific in that regard. The way to beat the National Labor Relations Board is to be very specific with your policies, not overbroad, not too general. We got the Section 7 rights out there that we need to worry about. So just recognize that they might review your handbook and be prepared. So again, code of conduct, affirmative obligations, prohibited things. Some operational policies, hours of operation, what's the employee's work schedule, meal and break periods. Remember, a break, 10 minutes, that is a paid time. A meal period, the labor law has in place rules for when a meal period is required, both the initial one, and if they work overtime, there's a second one that might kick in. You got to follow the meal period rules. Now, if you're a union, you can modify the meal period rules. There's case law that says that, but I think you still, you got to have the meal period. The question is how long. You can also apply, generally, it's either a 30-minute or 60-minute meal period, depending on the type of organization. You can make an application to the Department of Labor for a 20-minute meal period. They will come in and investigate to see if it's appropriate or not appropriate. There's also one-person shift rules about eating a meal. That exists and you have to follow it. I'm not saying cover everything. I think it's more keeping it general and notifying employees what they can and can't do. Lactation breaks, the expression of breast milk in the workplace. The Department of Labor, New York State Department of Labor, rolled out a model policy. I simply tell you, adopt it, but you need to implement it. You need to read it, understand it, and put it in place in your organization, because not every business has a lactation room. We have a wellness room here. It's used for multiple purposes. But some businesses we don't have any extra rooms, Mike. It's an open floor. What do? Well, the lactation policy is very clear what you have to do, and the regs are clear. You have to do dividers, cubicle dividers. They have to be a certain height. And I think, don't quote me, it's either 8 or 10 feet. It's an unusual height, and you got to buy special ones. So read that policy, adopt the state's model policy. Just be cautious. You make sure you implement it and you do it properly. Another question that just popped up, it relates to the prior topic, which is fine. We have electronic files. Can the medical electronic folder be kept inside the electronic personnel folder? Only if you are complying with the access rules and who can access and not access that file. So, there are the rules as to who can gain access to a medical file are limited. Supervisors will need to know, the record keeper, but not everyone within the record keeping department. So it's generally speaking, I think most of your HR department would count. However, if some of you may have a giant HR department, I don't know. And I don't think you want everyone getting access to those files, because I think it's a law violation. Emergency closing in bad weather. How are we going to notify employees? Don't come to work. If you're not exempt employee, depending on which minimum wage order you're covered by, there's something, it's the employee shows up for work. Go home. Well, now we have show up pay. That is an issue. And maybe you owe them 4 hours at the state's then minimum wage. So how are we going to tell them, stay home, don't come to work? Put that in there. It will avoid non-exempt employees showing up and you having to pay show up pay in that regard. Time cards, what's your policy? Have some type of time card system. There's so many types now. Just tell employees what to expect. The biggest thing is don't lie, don't cheat, and no buddy punching. I would tell you, put a camera by the time card machine if there is one. There are these apps now. Well, we're seeing employees cheat. They're just leaving their house, but they're logging in, they're here. Well, some of you got these geolocators in it. Tell them what their expectations are. Business expenses, who can do it, who can approve it, what people can do and not do depending on their position. Some required policies, then I'll put these in the absence from work policies. Paid sick leave. Now, please remember, there's a lot of room for creativity in paid sick leave policies. Let me just throw out a couple examples. Can I have different accrual rules depending on the type of employee? So non-exempt employees, we make you accrue. Exempt employees, we front load. Sure, that's legal. There's no problem with it, but it must be in your policy. Paid sick leave is one of the things that I tell employers we can be very creative with. Don't blindly adopt a rule. Have a chat with me first. Tell me what you're trying to accomplish, and we can see if we could do it. The New York State Department of Labor, in a series of comments to the final regulations that were published under paid sick leave did allow a payout provision. It's very limited in scope and must be clearly followed. It is actually contrary to the text of the statute, but that is the DOL's enforcement position on it. If you're interested in that, let me know. I can send you it's a Q&A. It's very, very short, and you can decide whether you want to do something like that. Paid Family Leave Act policy, the same thing, required. You must have it in place. Please note that the Comp Board and the DOL have made expansions of paid family leave, and I think we're looking at another one that's going to be coming up this legislative session. That policy has changed multiple times since the law went in place. So please make sure you keep it up to date. Family and Medical Leave Act, it's a federal law, 50 or more employees, generally speaking. That is a required employment policy as well. There have been numerous updates to FEMLA over the years, probably about 10, 12 times we've had to change this policy. I mentioned early on a required policy of vacation, personal time. The DOL, it's required by a provision in the labor law. Put it in writing. What's your PT? You call it vacation, you're calling it a PTO, or you're combining it with sick leave. And just from a lawyer perspective, I keep paid sick leave separate, and I want vacation/PTO separate from the sick leave. That's my preference. You can combine them, and we're seeing some issues with that. That's why I like keeping them separate. Voting leave is very limited. There's a voting employment poster that must be put up. Please make sure your poster is up. I keep the voting poster up year round, and tell your employees what your policy is on it. Is it a required policy? It is not. You don't have to have a policy. It's really just the poster that has to be put in place. Some employers who are covered by FEMLA or not covered by FEMLA have in place a general leave of absence policy. So it would say something like this. For those employees not covered by FEMLA, here is a general leave of absence policy, and everyone could need it. Maybe they haven't worked for you long enough, so they're not FEMLA eligible. But it's a general leave of absence. Again, you don't have to do it, just something to think about. And if you do it, because it's not required, it's employer discretion whether you grant it. It's not mandatory. That's the beauty of it. So you can grant it or you don't have to grant it. Jury and witness duty, generally speaking, I like having a policy on that. For the exempt employees, we can credit their salary, the amount they're paid by the court. I wouldn't do that in a million years because it's such a minimal amount. Military leave, USERA. We also have spousal military leave here in New York. Again, I think it's a good idea to put that in a handbook. Bereavement leave, same thing. What is your policy? I would realize that there's a provision in the New York State civil rights law that you must take into consideration as to who gets the leave and what have you. General attendance and call-in rules. I don't want an employee, no offense, and if you're doing this, I just encourage you to stop. Call in, no text, call in. I don't know who's on the other end of that text, and just the where Mike goes with some of these things. We get no call from someone. We get a text message. Is it really them, or should we call the cops and have them do a wellness check? Just don't be afraid of that. All right, so we got a question. PTO should be separate from sick leave. Yeah, it's a question. That's my opinion. You can put them together, or you can have vacation, what I call vacation and personal days separate in that regard. I think because the sick leave is very specific, I like holding employees to it. Otherwise, employees might use all of their PTO and vacation time and then suddenly get sick. And what bank are they going to hit? So that is a business decision, what you want to do. You can have them together. I just want you to realize that. That's just lawyer Mike talking. And I'm giving you a lawyer perspective, not necessarily a business perspective. Workers' compensation and short-term disability leave. What happens when you're out on workers' comp or short-term disability? Does vacation continue to accrue? I would hope not. You're costing yourself money. What are the rules on paying your health insurance? How are we going to do that? And one of the things that might be, it might be on a slide, a gross absenteeism policy. Hey, if you've been not a full-time worker in a year, you're fired. Don't do that policy. I think it's a very bad idea. There's lots of case law out there challenging those. Don't do a gross absenteeism policy. Compensation policies, pay rates and increases. Don't promise pay raises. Please don't. And I would, and I realize you have to be diplomatic with this. Put in the handbook, your pay may be decreased. Mike, that's not right. Well, let's look at it from a budgetary perspective. All of a sudden, we were at this, we're good, the business goes up and up and up, and all of a sudden the stock market crashes and our business goes down, 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 down. Are we going to fire everyone, lay everyone off, reduce salaries, some combination thereof? Don't have a policy that guarantees employment or pay raises. I'd simply say, depending on circumstances, your pay could be reduced. Not part of the handbook, but remember, if you're reducing someone's pay or changing any of the other information on the Wage Theft Prevention Act notice that the DOL requires, there's a lead-in period. I think it's 7 days before the start of the pay period. Just do it properly and make sure you take care of the paperwork. Overtime policy, typically it's who can approve it and the form of the approval that I'm interested in. What is the pay period and payday? Your payday should be set. Don't fluctuate it depending on the pay week. That's just going to get you in trouble. But you can legally change your payday. You would have to issue everyone new Wage Theft Prevention Act forms. Please note, I would only do it if there's a legitimate reason for doing so. You got to tell your employees what the payday is and what the pay period is. Payroll deductions, New York has, and I will say it, the most draconian rules when it comes to wage deductions. Too bad. You must follow them. Some states have no rules on wage deductions. New York does. They have pay advances and what can be deducted, very specific rules. You must follow them. Pay advances and employee loans. I'm not telling you what to do with your money, but from a legality perspective, don't do it. Self-help will not be as easy as you think because of the payroll deduction rules and the advancement of wages rules. So just keep those things in mind. Personal appearance and hygiene. Now, remember the ADA and human rights law is going to kick here. But if someone, and we actually had this, this happened to me at my old law firm years ago. I'll never forget it. I get off the elevator on the 14th floor, and all of a sudden, a skunk smell hits me. And I'm like, oh my God. One of our secretaries came to work after being sprayed by a skunk because she didn't want to lose the time. We sent her home. You're allowed to do that. Hygiene, dress code policies. You're allowed to have these things and use a little common sense. Every once in a while, you'll have an employee that comes to work smelling awful. Pull that employee aside. All right. Have that nice chat. Have a policy that you can point to saying you can't do this. I can't use soap because it's an illegal, a bad reaction. Now we're in the world of reasonable accommodation requests and how are we going to handle it? So again, have some generic type policy in place and don't be afraid to address smell issues at work, dress issues, hygiene issues, etc. I would have some type of confidentiality rule. What goes on at work stays at work. I don't want you talking about the rest of the world use a little common sense here. What are we really interested in protecting? Like medical information, client list, customer list, financial performance numbers, things that are not public. Please don't talk about outside of work. Drug and alcohol testing and prohibition policies. This is a lot, folks. Now, I can do a half day just on this one bullet point. Do you have a requirement to test, either by law, contract, or grant? Can I test for THC by law, contract, or grant? Do I want to have testing at all? Or do I just want to have an anti-prohibition? Thou shalt not bring marijuana cigarettes to work. Thou shalt not bring any product containing THC to work. And I can do the same thing for cocaine and heroin and all this. I just call them generally illegal drugs, but I'd call out THC like alcohol now and prohibition rules. I am setting if you don't have any testing requirements. I am a fan. You must have prohibition policies, in my opinion, and I would open a reasonable suspicion test. And give yourself that option if you want to test the employee. Personal conduct, act professionally. It's going to go hand in hand with the code of conduct. And realize, I'm giving you generic categories. You can combine some of these things. It's really the high level stuff I want you to get. Corrective action. Don't promise one form of discipline will occur before termination. Why? I might go right to termination. We had an employee recently, just now we're talking about drugs. He was auctioning off. Now listen to this, auctioning at work his medical marijuana. It's a felony for the person to have done that, but we fired him. We were able to stop it, and we went right to termination. It really depends, does it not? He punched the supervisor or he was 5 minutes late. The discipline will differ. Have your options: verbal, written, last, best and fine, last written warning, termination, suspension without pay. That's a wonderful discipline. It's had a lot of rules attached to it, but make sure you keep that in mind. Ethics, do you want your employees acting in a certain way? And there's an example. And this could go in your code of conduct under prohibited transactions as well. I've done a lot of litigation where the employee was taking gifts from a vendor that they were giving work to. Maybe a $25,000 trip the employee got from the vendor. What are the rules in that regard? I don't think you care if someone takes someone to lunch, but I'm sure if he goes into the world of $25,000 trips, you care because it's a kickback, it's a bribe, however you want to look at it. Okay, so in essence, those are the key points that I wanted to cover. Basically an hour. I tried to keep this to. Use common sense. The handbook is your front line of defense. You must have in it all the mandatory policies. It goes hand in hand with your hiring process and make sure all the forms are accurate. I realize, I truly do, that the government imposes upon us very lengthy policies, with the expression of breast milk, the sexual harassment, the FEMLA policy, paid sick leave, paid family leave, and others. However, they've also helped us out, and they've given us model policies for the most part to use. Adopt them, read them, complete them, because they're all incomplete, and make them your own. It is very important that you do that. And sexual harassment, who do you want them to complain to? How do I contact that person? Where is their physical address? What is their phone number? What is their email? Put those things in a policy. I don't think the handbook is a difficult thing, but it is a time-consuming thing. So let me just tell you, our normal process takes about 3 months to get a handbook in place, whether we're reviewing it or writing it from scratch. This is what you should do. Draft your handbook. Review it internally with managers and non-managers. Hey, this is a draft. Does it make sense? Some of the best comments that we get on draft handbook comes from rank and file employees saying, Mike, this is not how it works. HR has it wrong. No offense, because you may not be on the floor working and maybe have 1,000 employees. But do that due diligence. Have what I call a common sense review, and then do a legal review. It's both. And just remember, just because it's legal doesn't mean it should be in a handbook. Let me give you an example, and I'll end with this. All employees are entitled to 104 personal days every year. They're called Saturdays and Sundays. Is that a legal policy? Yes. If I put that in my handbook, would my workforce be very upset with me? Yes. That's an example of a legal policy that's stupid. Just because it's legal doesn't mean it should be in your handbook. The two-level approach, the company level, what I call the common sense approach, and the legal review. Then keep your handbook up to date every year. Be on the lookout for updates from the federal government, the state government. And the last thing I will say is don't overlook local laws. We have local laws in place in many parts of the state: Syracuse, Rochester, Buffalo, Albany, New York City, Westchester County. You might have to tweak your handbook in that regard. So with that, I'm going to end. I'll simply point out we'll have our next webinar that I'm doing on March 14th. It will be on criminal convictions in the hiring process. And I'd encourage you all to attend that, because the rules are changing, and you need to get this right. So with that, I'll turn it back to the chamber. I don't know if there are any other questions, but we'll go from there.
All right, thank you, Michael. We will share the link to the recording with you later on. You can also visit chemungchamber.org to register for upcoming webinars or find recordings of previous webinars. As Michael had said, for March 14th, we're going to be doing the criminal convictions. I just threw that up on the website, so you can register for that today. On March 28th, we're going to be doing elder financial exploitation education as an in-person seminar with First Heritage Federal Credit Union. And April 9th will be do's and don'ts of social media for small businesses with long-run communications in-person event. For anyone interested in chamber membership, please contact the chamber at info@chemungchamber.org or call 607-734-5137. Many thanks to Michael Schiatti with Barclay Damon, and to everyone for joining us today. Have a great day, everyone.
Thanks, everyone. Take care. Thank you.